The Little Sisters of the Poor are actually the second client I have who has paid for legal services in cookies. The Amish were the first, and I have to say they are world-class bakers. So we're always thankful for that. Who are they besides being world-class bakers? They are an order of nuns who's dedicated their lives to serving the elderly poor. And what that means for them is that they try to treat everyone in their care the same way that they would treat Jesus himself if he were there receiving care at one of their homes. We represent the Little Sisters of the Poor, along with East Texas Baptist, Houston Baptist, and other religious groups who are now before the Supreme Court in these consolidated cases. So the Little Sisters of the Poor care for the poor not just because it's a good thing to do, although it certainly is, but because they are inspired and motivated by their faith. They have given their lives to following their faith and serving those in need, and now they are faced with a stark choice. Are they going to continue to follow the faith that has inspired them, and for doing so, are they going to face millions of dollars in government fines? Before I dive into the legal test, I know you're all very eager to hear about the legal test. Before I do, I wanted to back up for just a moment and talk about the big picture view, looking at the Affordable Care Act and the mandate specifically. It turns out that when you look at the Act and the mandate, there are a lot of different exemptions, a lot of different rules that apply for different people. In fact, when you add it all up, 100 million Americans under the age of 65 do not have insurance plans that are required to comply with this mandate. That's 1 in 3 Americans who are under the age of 65. And so as a policy matter, it's hard to understand why going after and challenging the Little Sisters of the Poor is the best way to remedy this problem. I'd say it's probably never a good idea to be on the other side of a case from the Little Sisters of the Poor, but if you must, they're...
Sign them up as your plaintiff regardless of the type of case you're bringing.
Regardless of the issue, you're talking about 45 million Americans who are on grandfathered plans. You're talking about Americans on Medicare, Americans on TRICARE, who don't have this level of mandated coverage. And so it's hard to understand why it's important to fight these religious groups all the way to the Supreme Court rather than try and remedy this problem by closing other loopholes in the law instead. And I'll come back to that in a moment, but I want to talk about the test. So these cases have reached the Supreme Court under the Religious Freedom Restoration Act, affectionately known as RFRA. Under RFRA, there's a simple 3-part test. Sometimes it's described as a 4-part test. I'm going to talk about it in 4 parts today because I think it helps to illuminate one of the problems here. You have to have first a sincere religious exercise that is substantially burdened by a government action. If those 2 things are true, then the burden of proof shifts to the government to show that it has a compelling interest in what it's doing and that it is using the least restrictive means available in order to do it. The religious exercise here is sincere. Nobody has challenged the sincerity of the Little Sisters of the Poor or these other groups. And yet I think that the courts have often gotten hung up on this issue of what is the religious exercise. RFRA, by its terms, protects any exercise of religion, and that's important. This law was passed by Congress almost unanimously in response to a Supreme Court decision, Employment Division v. Smith, that had to do with Native Americans who were using peyote, and because of that could not qualify for unemployment insurance. And so RFRA contemplates that it's going to reach religious exercises that are not well understood or not mainstream. Here we're talking about a couple of religious exercises. It's the refusal to participate in distributing these services, which are contrary to the Little Sisters' faith. And it's not just the refusal to use them or to provide them directly, but also the religiously motivated refusal to be part of the government scheme, to allow the government to come in and use their insurance plan to do what they cannot themselves do in good faith. This gets into notions and ideas of complicity. When is it wrong for me not just to do something, but to participate in somebody else doing it? We all understand this idea. If somebody asks for a knife so they can, ask me to hand them a knife so they can cut a cake, I'm going to do it. If they ask me to hand them a knife so they can stab someone, I'm not. Which is a very different situation than you have here. And yet it gets to this idea that what you're doing and why you're doing it, what you're being part of, really does matter morally. This is not a question that the Article III courts are really fit to resolve. This is a question of theology and morality. Now, it is one the courts are familiar with. There were several former U.S. attorneys general who submitted a brief on this subject to the Supreme Court, saying that the ideas of complicity that we saw here were actually quite similar to things that the Justice Department argues when it comes to criminal law. And there are 50 Catholic theologians who submitted a brief to the court explaining how this view of complicity works within Catholic theology. It is a theological determination. It's a long-standing and deeply rooted religious belief that they cannot be part of this scheme and this system, and it is sincere. And so the question for the courts is not whether they agree with or like this particular religious exercise. The question is whether there is a substantial burden on that exercise, and the answer is yes. Under the Supreme Court's decision in Hobby Lobby, the same penalties that are at issue here were deemed to be a substantial burden. When your faith compels you to do something or not to do something, and the price for doing that or not doing that is a government fine, then you have a quintessential substantial burden. Here, the fines run into the tens of millions of dollars. The exact same statutory penalties that were addressed in Hobby Lobby, found to be substantially burdensome here, are also substantially burdensome there, are also substantially burdensome here. It should be an open and shut case on substantial burden. So then the question is, what can the government do? The government has to prove that it has a compelling interest in imposing this mandate on the Little Sisters and the other religious groups. And I don't believe it can do that. When we're talking about compelling interest, it's important to note that the question is not whether this interest is important, whether it is something generally that the government wants to or should address. The question is whether the government has treated it as being compelling in this particular case, whether they need to impose it against this particular religious claimant that they have before them. Compelling interests that have turned out not to be compelling in a particular case include things like health and safety in the Lukumi case involving animal sacrifice, include things like the nation's drug laws in the Ocentro case involving the use of a hallucinogen in religious ceremonies. While those interests are compelling in the abstract, they were not compelling in the particular case. And the interests the government is raising here are not compelling here. And you can see that because of what I spoke about at the beginning. There are 100 million Americans who don't have this coverage. There's a loophole for 45 million Americans who are on grandfathered health plans. Their employers don't have to provide these services, don't have to provide all of them, and don't have to provide them free of charge. Also, the government has exempted its own programs from this mandate. Medicare doesn't have to comply with the mandate and, in fact, doesn't cover all the required services. Now, you're thinking, Medicare, that's what grandma's on, why does it matter? Actually, there are 9 million Americans under the age of 65 who are disabled and are on Medicare for that reason. And the government does not comply with the mandate when it comes to Medicare. TRICARE is also exempt. TRICARE is the insurance used by our military service members and their families. And the government, when it comes to military service members and families, has chosen to exempt TRICARE, not to cover all the mandated services, and to charge copays for those services. The government, and especially its amici before the Supreme Court, have been saying that this issue of copays is really important. It has to do with incentives that people use and follow. And yet, when it comes to its own plan, it's decided that charging our service members and their families copays is just fine. So I don't see how the government can prove that it has a compelling interest when it has exempted plans covering tens of millions of Americans, and in fact the plans that it itself runs and administers. So the question then is, have they used the least restrictive means available? If the government fails on either of these prongs, it loses. I think it fails on both. The government has a lot of opportunities in other ways to deliver this particular package of services to women. In fact, they admitted as much in their brief to the Supreme Court. We had criticized them in our own briefing for the small business exemption. If you're one of the 35 million Americans who works for a firm that employs fewer than 50 people, then your employer does not have to provide you with insurance at all. And the government said, well, that's okay. That doesn't undermine our compelling interest, because if the employer does provide insurance, then it'll have the mandated services. And, by the way, these women can get these services in other ways. They can go onto a plan that belongs to a family member. They can go onto the exchanges and purchase a plan for which they may or may not qualify for a subsidy. They could purchase a plan directly from an insurer. They might qualify for other government programs like Medicaid, or I would add Title X. The government has a lot of different ways that it tries to address address this problem and this issue. It does not need to rely on the little sisters of the poor to do it. And so that is the basic case that we'll be presenting to the Supreme Court next week, that the Little Sisters of the Poor have a sincere religious exercise, that it is burdened by this mandate, that the government does not have a compelling interest in trying to force them to do what it won't force hundreds of millions of other plans to do, and that the government has a lot of other methods and means at its disposal. And we believe and are very hopeful that the Supreme Court will rule that way.